What's up, everybody? So the state of Wisconsin has officially responded to Steven Avery. It was posted just a short time ago on September the 8th, 2021. I will link it in the description below so you can go have a read for yourself, but let's go over it here. It is a 12-page document. Right in the table of contents, argument: this case does not meet any of this court's criteria for review. Whew, they're coming in hot. This court should deny Steven Avery's petition for review. As he has done throughout this proceeding, in his petition, Avery has misrepresented the record. As the Court of Appeals repeatedly noted, the law, the lower court's opinions, and even his own arguments. The only question properly raised by this case would be whether the Court of Appeals erred when it found that Avery's motions failed to plead sufficient facts that were actually supported by some evidence to both overcome the procedural bar, Wisconsin Statute 974.06, and require an evidentiary hearing. Even a casual review of the record shows that the Court of Appeals correctly applied the law and appropriately held that the Circuit Court was not required to hold a hearing on any of Avery's issues because Steven Avery's motions were all utterly devoid of factual support sufficient to lead to the conclusions Avery claimed. Wow. Avery's motions were insufficiently pled, and the Circuit Court had discretion to deny them without an evidentiary hearing. So at best, Steven Avery asks this court to engage in error correction of non-existent errors. This court is not an error correcting court. Did they even read their last response? It was riddled with errors. This is ridiculous. And there is no compelling legal issue here that meets any of the court's criteria for review. There is nothing novel, unsettled, or any need for clarification about what a defendant must plead in his section 94.06 motion to be entitled to a hearing or to overcome the procedural bar on raising claims that could have been raised earlier. Nor can Avery show the Court of Appeals' rejection of his claims is in tension with any United States Supreme Court or published Wisconsin cases. In short, despite what he appears to believe, the fact that Avery's case was the subject of a television show does not absolve him from following the well-established rules of Wisconsin procedure. It does not entitle him to a hearing on insufficiently pled claims based only on raw speculation and mispresentation of the facts, and it does not entitle him to this court's review of a perfectly sound decision by the Court of Appeals. This case does not meet any of the court's criteria for review, and there are no compelling reasons for this court to hear it. This court should deny Avery's petition. And now it talks about the argument. This court's function is to develop and clarify the law. Accordingly, this court does not grant review unless the case presents as an important legal issue on which the lower courts need guidance. This case does not present such an issue. The section, the 974.06 motion that Avery filed in June of 2017, was his third motion seeking post-conviction relief. He had a direct appeal in 2011, and he filed a previous section 974.06 motion in 2013. The Circuit Court denied Avery's 2017 motion and his many supplements to it without a hearing because he failed to show a sufficient reason for raising the claims previously. He's shown all kinds of claims, and the record conclusively demonstrated that Avery could not show he would be entitled to relief on any of his claims. Steven Avery misrepresented the conclusions his experts reached and otherwise relied on wildly speculation and allegations. The Court of Appeals agreed, holding that had not provided a sufficient reason why most of his claims could not be raised previously. For those which he did provide sufficient reason, he had not provided sufficient material facts in his motion that were supported by the record that could establish ineffective assistance of counsel, newly discovered Brady evidence, or constitutional due process claim. This court has also held quite clearly that the circuit court does not need to hold a hearing if the defendant's motion makes allegations or if the record conclusively demonstrates that the defendant is due no relief. In other words, contrary to what Steven Avery claims, it is well established that the circuit court does not have to grant a hearing on allegations pled in the motion that the record demonstrates are not true, and as the Court of Appeals properly recognized, the claims Avery made in his motion were misleading, contradicted by the record, speculative, and did not contain sufficient material facts that would establish what he claimed. Avery's new experts all reached conclusions that were consistent with Steven Avery's guilt, and in his motion, Steven Avery simply falsely represented what they said, meaning it would be impossible for him to establish at a hearing that a trial or post-conviction counsel were ineffective for failing to conduct these tests, nor could he meet his burden to prevail on a newly discovered evidence claim. Virtually all of the contents of the CD, the Bobby Dassey computer CD, were indisputably turned over to the defense along with Agent Fassbender's investigative summary telling Steven Avery what the state found on the Dassey computer, meaning Avery did not plead sufficient facts showing how he could prove a Brady violation if a hearing took place, and there is no due process right to post-conviction DNA testing, so Avery did not even plead a claim about the bone fragments, but even so, Avery did not provide any facts, if true, would show that if the bones were from the Manitowoc gravel pit were human and the victims, he could not be the killer and the person who put them there. He did not plead sufficient facts to explain why the bone fragments could be actually or even potentially exculpatory. Accordingly, he failed to plead facts to show how or why this evidence was at all material. Finally, it is beyond argument that statutory claims such as Avery's argument that the state violated Section 968.205, which it did not do in any event, cannot be raised in a Section 974.06 motion. The Supreme Court has also made it crystal clear that Arizona v. Youngblood does not apply to destruction of evidence post-conviction nor recognize a due process right to post-conviction DNA testing, meaning Avery did not raise any constitutional claim regarding the state's releasing some of the bone fragments to the Halbach family after Avery's appeal concluded in 2011. In short, Avery's motion did not include sufficient material facts that would entitle him to a hearing because he did not provide sufficient facts that would entitle him to the relief he seeks. In other words, his motion was insufficient because he did not allege sufficient facts that were supported by the record to show that he could establish any constitutional violations at a hearing. This case does not present any novel, unsettled, or important legal issues, and the Court of Appeals' opinion applying the pleading standard is exactly in line with the decisions of this Court and Supreme Court of the United States. Review here would simply be another walk down the extremely well-trodden path of the pleading standard for Section 974.06 motions. There is no need for further clarification of the pleading standard. Courts across the state easily and properly apply it every day. This court's scarce resources should not be spent reviewing the Court's appeals' simple and correct application of standard that has already been explained in existing case law. Conclusion: this court should deny Steven Avery's petition for review dated on this day, September 8th, 2021. Attorney General of Wisconsin signed it, and the Assistant Attorney General of Wisconsin also signed it. Wow, okay, so I didn't go over everything. It's just a summary. You can go check it out for yourself. The conclusion, like I just read, is the court should deny Avery's petition for review. I mean, no one's surprised, but at the same time, they are clearly doing the wrong thing. Someone, somewhere, has to end this ridiculousness that's going on. in this case. At some point in time, Kathleen Zellner is going to get someone with some common sense to look at this case from the other side and be like, at the very least, it deserves another look. It deserves an evidentiary hearing. He deserves another trial. So much ridiculous stuff happened in this case. And for her to keep getting denied over and over and over again is absolutely ridiculous. It's insane what, in my opinion, allegedly, they're all getting away with. Just, it's so sad, so disgusting of the Attorney General, the Assistant Attorney General, whoever wrote this up. You should be ashamed of yourselves. It's just stupid. But anyway, it is linked in the description below. It is not the decision, of course, we were all looking for, but I don't think this is going to stop Kathleen Zellner. I think she will continue pushing forward, and she will eventually, hopefully, get the right outcome. Thanks for watching, everybody. Like, share, subscribe to the channel. Hope you all have a great day.